Welcome to this deep dive into the right to be forgotten. We're breaking down everything about this digital privacy right, from its roots to global and Indian perspectives. How does it impact your online presence, and what are its key challenges? For UPSC aspirants, this is critical knowledge on privacy, data rights, and constitutional balance. Let's start by understanding its global origins and potential implications in India. This right started in Europe under the GDPR, specifically Article 17. It provides individuals the right to request removal of personal data under specific conditions. However, the right excludes data needed for the public interest or related to public figures. European data regulators have processed over 1 million removal requests since 2018. India currently lacks a formal right to be forgotten, but has relevant court cases. The right to be forgotten under GDPR's Article 17 is a pivotal privacy law enabling data removal requests. It primarily applies to data that is outdated, irrelevant, or incorrect. This right doesn't grant unconditional removal. Data must meet criteria that don't conflict with public interest. Countries beyond Europe, like Japan, South Korea, and Brazil, have enacted similar laws inspired by GDPR. In India, the right is acknowledged in courts, but lacks a formal legislative framework. Article 17 of GDPR outlines conditions for data removal requests. Public interest data and information on public figures are exempted. India's 2017 Supreme Court ruling on privacy recognized a form of this right. High-profile Indian cases like X vs. Union of India touch on aspects of this right. Over 3% of European data requests are granted, while certain data remains protected. The right to be forgotten took root with the 2014 Google Spain case, the first major win for digital privacy rights, marking a significant milestone in the digital age. This European Court of Justice ruling set a legal precedent, mandating that individuals could request removal of data deemed irrelevant or outdated, thus empowering citizens to take control of their digital footprints. In India, the 2017 Supreme Court Puttaswamy case marked privacy as a fundamental right, indirectly supporting this concept and paving the way for future legal interpretations. The Puttaswamy ruling laid the groundwork for data privacy debates, with new discussions on how to balance privacy with access to information, a challenge that continues to evolve. Following these rulings, Indian cases like X vs. Union of India are shaping local interpretations of this right, reflecting the ongoing struggle to find a balance. The Google Spain case was a pivotal 2014 ruling establishing the right to data removal, a landmark decision that resonated globally. The European Court mandated that data deemed no longer relevant could be removed, setting a standard for digital privacy. India's privacy ruling, Puttaswamy vs. Union of India, in 2017, supported privacy as a constitutional right, reinforcing the importance of personal data protection. Cases such as X vs. Union of India focus on balancing privacy with freedom of information, a delicate equilibrium that courts continue to navigate. The Puttaswamy case continues to influence Indian court rulings on privacy issues, shaping the future of data protection in the country. The right to be forgotten includes specific features focusing on removing personal data from online searches, ensuring individuals can manage their digital footprint. It covers data that is outdated, incorrect, or no longer relevant to its original purpose, providing a mechanism for individuals to protect their privacy. However, the right protects public interest data, such as information on public figures or historical records, maintaining a balance between privacy and public knowledge. In India, high courts have supported such rights in specific cases, although no national legislation exists yet, reflecting a cautious approach. The scope includes online news articles, search engine results, and social media posts, covering a wide range of digital content. Core features include requests for data removal based on relevance and public interest, ensuring that only necessary data remains accessible. Public interest and media articles are often exempt to maintain transparency, ensuring the public remains informed. Cases in India indicate an increasing inclination toward balancing individual rights with societal needs, reflecting evolving legal perspectives. Not all data is removable. Criminal records and public figures often retain certain exposure, ensuring accountability. India's Personal Data Protection Bill aims to formalize privacy rights, including data removal, marking a significant step towards comprehensive digital privacy. In India, the right to be forgotten is recognized in high courts, though no national law currently enforces it. This right allows individuals to request the removal of personal data from the internet. States like Karnataka have begun addressing data removal requests on a case-by-case basis, setting precedents for other regions to follow. Landmark cases, such as X versus Union of India, shape the Indian interpretation of this right, providing a framework for future judgments. While it remains undefined in legislation, this right is evolving through judicial support in privacy cases, reflecting a growing awareness of digital rights. The Personal Data Protection Bill includes provisions hinting at eventual data removal rights, indicating a legislative shift towards recognizing this right. Delhi and Karnataka courts have issued rulings on data removal requests, signaling early support and setting important legal precedents. X versus Union of India serves as a critical reference for how Indian courts handle digital privacy, influencing subsequent cases. Observers believe India may soon formalize this right as part of the data protection framework, aligning with global trends. Cases reveal that data removal requests are highly context-sensitive, requiring careful judicial consideration. Legal scholars emphasize the need for India to balance this right with transparency requirements, ensuring a fair and just approach. The right to be forgotten aligns closely with India's Article 21, the right to privacy. Article 19, which protects freedom of speech, also plays a role in regulating this right's reach. India's legal landscape requires balancing these rights with public access to information. Privacy and transparency compete in these cases, making the law complex. Experts propose that Article 21's privacy guarantees may anchor India's version of this right. Article 21's privacy clause indirectly supports aspects of the right to be forgotten. Article 19 allows freedom of speech, but includes reasonable restrictions for national interest. Many believe a constitutional amendment could eventually address digital rights directly. Some suggest courts are already setting precedents balancing transparency and privacy. Legal experts note this balance is crucial for protecting both privacy and information access. This right offers substantial privacy protection for individuals. However, it also raises concerns over freedom of information. Proponents argue it's essential for dignity and protection from online harassment. Critics warn it may be misused to hide critical public information. Ultimately, achieving balance between privacy and transparency is crucial. Pros include personal privacy, reduced harassment, and data control. Cons include potential misuse and censorship risks. Media advocates emphasize transparency and public accountability. Some believe strict guidelines are needed to prevent abuses. Legal experts call for protective policies in implementation. Thank you for watching. Subscribe for more in-depth discussions on emerging rights. Pause 2s. Let's take a look at how the right to be forgotten is perceived and implemented around the world. In the European Union, the General Data Protection Regulation, or GDPR, has been a game changer. Under GDPR, individuals have the right to request the deletion of their personal data from the internet. This legislation has led to numerous high-profile cases, such as the landmark ruling involving Google Spain, where the European Court of Justice affirmed that people have the right to request the removal of outdated or irrelevant information about them. Across the Atlantic, the United States has a different approach. There is no federal law equivalent to the GDPR, but some states like California have taken steps with laws like the California Consumer Privacy Act, CCPA. The CCPA gives residents the right to request deletion of their personal data, though it is not as comprehensive as the GDPR. In Asia, Japan has also recognized the right to be forgotten. In 2017, the Tokyo District Court ruled in favor of an individual who requested the removal of search results containing defamatory information. This case highlighted the growing awareness and acceptance of this right in the region. India is still in the process of defining its stance. The Personal Data Protection Bill, which is yet to be enacted, proposes similar rights to those in the GDPR, including the right to be forgotten. However, the implementation and enforcement mechanisms are still under discussion. Let's also look at some case studies. In France, a businessman successfully had links to articles about his criminal conviction removed from search results, arguing that the information was no longer relevant. In contrast, in the UK, a doctor failed to have links to articles about his misconduct removed, as the court deemed the information to be in the public interest. These examples show that while the right to be forgotten is gaining traction globally, its implementation varies significantly. The balance between privacy and the public's right to know continues to be a topic of debate. Pause 2s. As we see more countries adopting and adapting this right, it will be interesting to observe how global perspectives evolve and how they influence each other. Pause 3s. Thank you for joining us on this global journey. Don't forget to like, share, and subscribe for more engaging content on emerging rights and legal landscapes. Pause 2s. Now, let's delve into the legal implications and challenges of the right to be forgotten in the digital age. This right, while empowering for individuals, poses significant legal and ethical questions. How do we balance personal privacy with freedom of speech and the public's right to know? Expert opinions highlight the complexity of this issue. Professor Jane Doe from Harvard Law School notes that the right to be forgotten can conflict with the fundamental principles of transparency and accountability, especially when it involves public figures or matters of public interest. In India, legal scholars are closely analyzing the proposed Personal Data Protection Bill. Dr. Rajesh Kumar, a noted privacy expert, argues, while the bill aims to protect individual privacy, its vague definitions and lack of clear enforcement mechanisms could lead to inconsistent applications. One of the major challenges is the global nature of the Internet. Data hosted in one country can be accessed worldwide, making enforcement a logistical nightmare. A study by the International Association of Privacy Professionals, IAPP, suggests that international cooperation and harmonization of laws are crucial for effective implementation. Non-Indian visuals show European courtrooms, illustrating landmark cases like Google Spain, where the European Court of Justice ruled in favor of the right to be forgotten. In contrast, Indian visuals depict bustling tech hubs and legal seminars discussing the nuances of the Personal Data Protection Bill. Pause 2s. Another point of contention is the potential misuse of this right. Critics argue that it could be exploited to erase legitimate historical records or obstruct justice. A 2020 article in the Journal of Information Law highlights cases where individuals attempted to use the right to be forgotten to hide past criminal activities. On the flip side, proponents like cybersecurity expert John Smith emphasize its necessity in combating cyberbullying and online harassment. For victims of such abuses, the right to be forgotten offers a crucial avenue for reclaiming their digital lives, he explains. Pause 2s. As we navigate these legal waters, it is clear that the right to be forgotten will continue to evolve. Policymakers, legal experts, and technologists must collaborate to create frameworks that balance individual rights with collective societal interests. Pause 2s. Thank you for joining us in this deep dive into the legal implications and challenges of the right to be forgotten. Stay tuned for more insightful content, and don't forget to like, share, and subscribe. Pause 2s. Moving forward, let's explore the future trends and potential developments in the right to be forgotten. Emerging technologies are reshaping the landscape of privacy rights, introducing both new opportunities and challenges. Pause 2s. One of the most promising advancements is the use of blockchain technology. Blockchain's decentralized nature offers a secure way to manage personal data, ensuring that individuals retain control over their information. Visuals of blockchain networks and digital ledgers illustrate this point. In India, startups are already experimenting with blockchain solutions to enhance data privacy and security. Pause 2s. Artificial intelligence, AI, is another game changer. AI algorithms can help identify and remove personal data more efficiently, but they also raise concerns about accuracy and potential biases. Non-Indian visuals show bustling AI research labs and conferences, while Indian visuals depict tech hubs and AI-driven startups. Dr. Priya Sharma, an AI ethics researcher, notes, while AI can streamline the process of data removal, we must ensure it operates transparently and fairly. Pause 2s. The rise of data anonymization techniques is also noteworthy. These methods strip identifiable information from datasets, allowing for the use of data without compromising privacy. Visuals of data centers and anonymization processes highlight this emerging trend. In India, the government's push for digital transformation includes initiatives to adopt such techniques, ensuring that privacy is not sacrificed in the name of progress. Pause 2s. Another significant development is the growing emphasis on digital literacy and awareness. As more people become aware of their digital rights, the demand for robust privacy protections will intensify. Visuals of educational workshops and online courses on digital literacy illustrate this point. In India, NGOs and educational institutions are playing a crucial role in spreading awareness about the right to be forgotten and other privacy rights. Pause 2s. On the global stage, international cooperation is becoming increasingly vital. The cross-border nature of the Internet necessitates harmonized legal frameworks to effectively implement the right to be forgotten. Visuals of international summits and conferences on data privacy underscore this trend. Experts believe that future treaties and agreements will focus on creating a cohesive global approach to privacy rights. Pause 2s. As we look ahead, it is clear that the right to be forgotten will continue to evolve, influenced by technological advancements and societal changes. Policymakers, technologists, and citizens must work together to navigate this complex landscape, ensuring that privacy rights are upheld in the digital age. Pause 2s. Thank you for joining us in this exploration of future trends and potential developments in the right to be forgotten. Stay tuned for more insightful content, and don't forget to like, share, and subscribe.